Good evening, everyone, and welcome. I'm Alex Lavoie. I'm the director of the Transition Center here at Perkins School for the Blind. Thank you for joining us for our discussion on guardianship. Let me just see here. Okay, you're still letting people in. All right, well, we're going to get started. So this is our fifth event in our year-long series of transition talks at Perkins. We are just so grateful for our growing transition community and for this dedicated group of families and professionals from across the country that took the time to join us tonight. So thank you. If this is your first session with us, we have all of our previous events recorded and available to view. They're all posted online on our website, so we can share that link. And we've covered a number of important topics throughout the year: IEP planning, affordable housing options. Our session last month focused on college pathways for students with disabilities. So we just really encourage you to, explore any of our previous sessions that feel relevant. We are so grateful this evening to Phelan and Fred Misilo and Grenier. We're lucky to have two Anns with us here this evening, leading us through a discussion on guardianship and decision-making. We know that this is a topic that can just be so daunting for families, and it's a topic that you have a lot of questions about. So, we hope this evening to be able to provide you with some clarity and guidance around, the right path forward for your family. Before I formally introduce our facilitators this evening, just wanted to spotlight a few upcoming events and new programs that are available through the Transition Center. We just this month launched our new virtual enrichment program called Pathfinder. Pathfinder focuses on building pre-employment skills for high school students. We are also opening another program this fall. That program is called Life Launch. And Life Launch is it's a full school year transition program, also for high school students in their final years of high school. And I can share that link, but we're thrilled to now be accepting applications for that program. And then in addition to the range of direct service programs that are available to students, we are thrilled to now be we're providing individualized guidance and consultation to families and with goals of supporting families and preparing action plans and preparing for the future. Anne can talk a little bit more about that as well. And then just finally, for our local families, looking forward to hosting our first in-person event on our Watertown campus in May. And we'll have a slide, and I'll share a few more details about the schedule for the day and about that event. But, just in summary, our overarching goal for all of the work we do is to provide young people and the families and school teams that support them with the tools that they need to transition from school to a fulfilling adult life. We'd really love to connect with you following this evening's conversation. If you have feedback or just to learn more about the questions about your needs and the questions that you have. So please reach out. You can find us at transition@perkins.org. We'd really love to hear from you. And again, just really appreciate that you've all taken the time to join us this evening. So with that, I will kick it over to Phelan. She's one of our transition specialists. She's been doing this work for a long time, and she'll be facilitating our discussion this evening.
Thank you. And I think we'll fire up the slide deck. Oh, so glad you're here. And I would welcome you to put in the chat box where you're from, if it's a state or a city, and whether you're a professional or you have an adult or a child and their age, because I love to collect data. I've noticed that some of my colleagues are here from DDS and Mass Rehab Commission, and some families from my previous employment. So I want to thank you and a colleague where I used to work. But more importantly, I also want to say you came here tonight, as Alex shared, and learning is a ever-growing process, and that's a real big growth mindset, that you're here tonight to learn more. And it's a wonderful opportunity tonight to have two esteemed, experienced lawyers who are going to shed a lot of insight in a free format. So thank you for taking advantage of that. So we'll start by kicking it off with a couple of slides, and then I'd like to introduce Fred Misilo, who is a colleague of mine. I've been working with you, Fred, for 15 years. So if you do a Google search, you will be quite impressed to know Fred has incredible background, including being the former president of the ARC of the United States. So thank you for being here.
Thank you for having us.
You're very welcome. And to Fred's colleague and a new professional connection for me is Anne Grenier, who has much expertise in guardianship and disability law. So thank you for being here, Anne, tonight.
Thank you.
So one of the most important concepts in transition is self-determination. And your children and your clients are all in different places in their life and they have different pathways. But we truly believe that it's important that students are self-determined and making the best choices that they're able to make with supports. And transition outcomes are far better when students are self-determined and learning how to advocate for themselves and make choices and decisions. So tonight, in the conversation with Fred and Anne, we will highlight so much about self-determination and why that's really important. We understand that you're here tonight because you want to protect your children, you want to protect the rights, but you also want to be mindful that there's vulnerability and dangers of exploitation and making bad decisions. And we honor that. And we understand as parents and professionals, you need to guide the process. But we hope that tonight you can come away with an understanding that there's alternatives that are least restrictive, but that sometimes you do need to make stronger decisions with full guardianship and other types. So we'll explore those this evening. So there's changes in the landscape. Fred was just telling us that he was in one of the first human rights advisory boards, Fred, in the 70s, I think you said?
I have to admit that I am that old, yes.
Yes. And I am too. And so human rights is going back to the Rehab Act of 73. If you saw Crip Camp with my hero, the late, great Judy Heumann, she was instrumental in leading and paving the way for human rights. And that's what this is about tonight. We do want to recognize the human rights, and that dignity at risk is something we all embrace, that we do need to make mistakes. We learn from those mistakes, and we have to honor that opportunity, even with people with special needs. And it's important to retain their rights. Tonight is a big voting day in the state of Massachusetts in some precincts. And I have encouraged my clients and students to exercise their rights and make informed choices, but also where they want to work and where they want to live. And for some people, getting married or forming relationships. There are ways to have enhanced supports that foster support systems that will prevent exploitation and vulnerability. And that can include, networks within the community. It can include, there's a new bank card that I think either Visa or some corporation, I can look it up, has a lot more constraints on it so that there would not be opportunities for abuse from third parties or others. Other enhanced supports are maybe systems on phones to prevent anything that could happen in a vulnerable situation with technology. So we want to consider some of those things. Our hope is that we come away with an understanding that you fought for your children to be in the least restrictive environment and to have a free and appropriate education. So moving forward, we want you to consider that in their future adult life, what would be the least restrictive option that they will be safe and that they will be supported. Most of your children will probably outlive you. So creating a system where they are having autonomy and as greater independence as they can is really important. But there are times that you do need to make stronger decisions about guardianship and legal matters, and we do respect that. Thank you. So tonight we'll be talking, and I'm going to turn it over to Fred and Anne. We might go over a little bit. So if we do, thank you. We want to have questions and answers during it. If I see a question that's pertinent to the conversation, I'll interject, and we'll have time at the end. So thank you. I'll turn it over to you, Fred and Anne.
Thank you. So when we're talking about making decisions for your child, here are some of the key concepts that we'd like to discuss. At age 18, your son and daughter is considered an adult, and legally, you as parents stop being your child's legal guardian. and consequently, parents may no longer be able to receive information from your child's healthcare team. So at age 18, the law presumes an 18-year-old is competent. In the eyes of the law, even an individual with significant developmental disability is legally permitted to make decisions on his or her behalf after age 18. So turning 18 is a time of transition. It does take time to develop the skills to be able to make decisions like an adult. There are a number of options you and your child can choose from to supportive decision-making, with the goal being choosing the least restrictive one to allow your child to develop decision-making skills. And underlying this concept is maintaining your child's right to self-determination and to privacy. If you're advocating for a person with special needs who's 18 years or older, you need the legal authority to speak on the person's behalf and to assist with financial transactions, to access his or her private health-related information. And that authority can come in a number of different forms, which include a healthcare proxy, a durable power of attorney, a health protected information authorization form, supportive decision-making agreements, and guardianship and conservatorship. With each of these choices, your child can be part of the decision of who is going to support their decision-making. Even with guardianship, the court reviews the medical documentation to allow the respondent to retain any rights. So the concept of maintaining the right to self-determination and the least restrictive approach are values no matter what option you choose. So I'm going to turn this over to Fred for the next slide.
Great, thanks, Ian, appreciate it. So thank you to Perkins. Thank you, Alexandra, Ann, and Janine, for your support through this planning process that brings us here tonight. I'm going to we'll get into some tactical choices that you'll be able to make, but I first want to provide you with some context. I understand that while I practice law in Massachusetts, as does Ian, and I practice in Rhode Island and Florida, there are a number of people in other states across the nation. So this presentation is really not Massachusetts specific, to the extent that, I'm going to talk somewhat about the position statement that I worked on several years ago when I chaired the Policy Positions Committee of the ARC of the United States. It's a collaboration with an Association of Intellectual Developmental Disabilities some time ago, where we created a position statement, and the bylaws of both the ARC of the United States and the AIDD require those two organizations to work together to create position statements. And there are 12.5 or more position statements on really important issues affecting individuals with disability, ranging from education to housing to economic sufficiency to employment, Medicaid, Medicare, long-term services and supports. And for many years, there was a guardianship position statement. And what we formed a work group made up of equal members from AIDD and the ARC, and had a series of meetings over months, deciding what are the issues that we needed to do to reformulate the position statement. And what came out of that was, at that time, something that we were proud of, we still are, in terms of some thought leadership. But it was autonomy, decision-making supports, and guardianship. And it was intentional not to have guardianship be the lead word in the caption, that we first and foremost wanted to focus on autonomy, the right of self-determination, as Ian said, and what are the support that are necessary to assist in making decisions, and how can we view this from a perspective on the individual level, the systemic level, public policy level. As Ann said, there is nationwide a presumption of competence. I'm going to go out on a limb here, but I think that the vast majority of states in the country have 18. There may be 1 or 2 out there that have a different age of emancipation, but 18 is the age where most people are presumed competent, and therefore, you're on your own, really, and then we need to build whatever kind of supports are appropriate in your jurisdiction. The priority from the ARC and from AAIDD and the thought leadership was we wanted to preserve legal capacity and recognition that guardianship is the transfer of decision-making authority from the individual to a third party. And so the concept is, in using the least restrictive alternative analysis, that should be not the default, but the last option, and we work towards that, going through a variety of options. And it's different from each state, describe it in a little detail as to why that is. The other piece that was really focused on, and we had public forums and we had educators and people, providing input and data. We did a long survey, is that thinking about this area, you can't ignore the fact that decision-making is not something that becomes, inherent in just because we're breathing and working, living human beings. It's a skill, and I know that at age 18, I was a different person than I was in 28 and probably at age 38. So you continue to learn how to maneuver various situations in your life for work, employment, and all the rest. So developing resources for families and individuals beginning prior to age 18, making it part of an IEP, that you're helping people make decisions should be an important aspect pre-18 and throughout one's lifetime, and that families should have the access for all of these issues. Next slide, please. So before I get to appointment of guardianship is a serious matter, and it is, you may have heard the concept of supported decision-making as distinct from guardianship or distinct from powers of attorney. There has been a recent phenomenon, I'd say in the last half dozen years or so, around states that have enacted supported decision-making statutes that really turns this whole question over on its head. When we reach to the last slide, you're going to see a variety of options that we have available here in Massachusetts and in the majority of states in the country, okay, which is powers of attorney, healthcare proxy, appointment of advocates, HIPAA releases, trusts, representative pay, all of those things. Supported decision in each one of those options is where the individual is making the decision, but the agents are also able to bind and make decisions on behalf of the principal. It's a fine distinction, but it's an important one. In a supported decision-making statute jurisdiction, and there are 15 states in the United States that have a supported decision-making. And in the District of Columbia, this is where an individual has an agreement. It's a supported decision-making agreement, and the individual is able to identify what is termed in the statute supporters, and those supporters are there. They have access to otherwise confidential information. By statute, they're granted that access. They're able to provide support around decision-making. But the individual, they have no decision-making authority. It's the individual who's making the decision, making the consent, binding the consent decision. So that's a very, very different. So when you hear about supported decision-making, it has to be limited to your 15 states, and I'll list them off based on research I did. It's Alaska, Colorado, Delaware, Illinois, Indiana, Louisiana, Nevada, New Hampshire, New York State, North Dakota, Rhode Island, Texas, Virginia, Washington, D.C., and Wisconsin. Notice Massachusetts, Michigan, we're not on it, right? So there is a bill pending, I know, in the legislature in Massachusetts to promote supported decision-making there. And there's some a good momentum in that area. So putting the supported decision-making aside, so if you're in one of those states, I would encourage you to Google it talk to somebody, a lawyer in your jurisdiction who can assist with regard to developing a supported decision-making, and see if it works for your family, see if it works for your son or daughter in your jurisdiction. If you're not in one of those 15 states, then you have to rely on the existing options, which is guardianship, alternatives to guardianship through the variety of statutes that we'll be reviewing in a few minutes. The reason that there is a negative reaction, and guardianship, by the way, is not a bad word. I'm guardian currently for one individual. I've been guardian for a number of people who really needed some protection because of a variety of circumstances. When a lawyer is appointed guardian of non-family members, sort of a guardian of last resort, the court says, well, who else can we appoint? So I was able to serve in those capacities, and it's necessary in a number of situations. But it is a serious matter because it is a transfer of decision-making authority from the individual to another party. And what we've heard from the self-advocacy community, nothing about us without us, is the message, is that many people find it stigmatizing. What I learned when I worked with the ARC and working with AAIDD closely was this recognition that when people are paired together and there's a group that's similarly situated who have guardianship, and I'm not a social scientist, so don't say, well, this guy said this and it must be true. I'm just suggesting what I was told is a phenomenon that drives some of these decision-making issues, which is people who are similarly situated who are under guardianship, and there are people who are similarly situated who are not under guardianship. And when people go through various experiences, the individuals who are not under guardianship are viewed as more capable, even though that's an illusion. It's only the existence of no guardianship. But as a consequence, they're afforded perhaps more opportunity in employment and higher expectations. One must think then, if you see and if you're treated differently, does that self-fulfilling prophecy then internalize? I don't know. I'm not a psychologist. I'm not a social scientist or a sociologist. I'm just suggesting that that's a lot of information that I heard when I worked through this process on developing the position statement. So it's just something for you to consider. There's an avoidance of conflict of interest. That's where one person's interest may be in conflict with another. You say, well, how can my interest be in conflict with my child's interest? That's more directed towards providers in some states that are also serve as corporate guardians, but who are providing residential supports to individuals. That is an inherent conflict, and that should be avoided when possible. So the whole emphasis here is not to get bogged down with the tail wagging the dog about, guardianship, no guardianship. So it's about improving life, and it's improving the quality of life. It's about enhancing someone's decision-making capacity to maximize their development throughout their life. So that's, if you want to read the position statement of the ARC of the United States and the AAIDD, it's on our website at Fletcher Tilton. You can also go on the ARC's website. It's thearc.org. There's a link that says who we are, and close, and you scroll down to the position statement and click on the one that says autonomy, decision-making, supports, and guardianship, and there you are. So with that, why don't we turn over to the next slide. So in a non-supported decision-making jurisdiction, so not on those 5, and these may be available in those jurisdictions as well. So that's an additional, but these are the exclusive options in a non-supported decision-making jurisdiction. The first, many of you may be familiar with if your son or daughter live or get SSI, Supplemental Security Income, or Social Security Disability Income, or DAC benefit. And really what we're talking about are what are the layers of protection, what are the layers of support that we can put on very specific areas of one's life. So a representative payee, if you think about it, the check comes in, it's not in the individual beneficiary's name, the SSI beneficiary or the SSDI beneficiary. that person's name is on it, but the mother or father or sibling, representative payee's name is on it. And they're the ones that have control over the check. They are accountable to the Social Security Administration on an annual basis to provide the annual representative payee report. And so that safeguards those funds through a representative payee. You don't need a conservatorship in court. You don't need a trust. It's just one person has the authority over that money, and they're sort of the custodian of those funds for that individual. The next is a durable power of attorney. Every state has a durable power of attorney statute. There's a uniform act for durable powers of attorney. It varies from state to state, but it is where a principal, an individual who's 18 years of age and older, has designated another individual to handle certain aspects of their financial and personal lives. It's a delegation of authority, and it's intended to be a collaborative delegation. And so if the individual can articulate competency and understanding the very basic tenets of an agency relationship, of an agent that you're going to help, mom and dad are going to help you with talking to your educators, talking to your doctor, talking to your job coach, your DDS service coordinator, service, the houseman, whatever in the person that you need to be working with, they'll have the authority to not only discuss things with the individual, the third party, but also to make decisions. So that's where the self-determination statute's different. Remember, the self-determination statute, the individual themselves are making the decision, whereas what's on the books now in most jurisdictions is you have a delegation of authority that's voluntary, competently given, so that you avoid guardianship in many circumstances. HIPAA, most of us know HIPAA. Oh, let me scroll back. The durable power of attorney, HIPAA release, and healthcare proxy and appointment of advocate are all usually part of one package that could be developed and normally is developed during the turning 18. When you're turning 18, those things are discussed and presented to individuals. All of these are revocable. They can be torn up, they can be amended. We also recommend, when people are choosing these alternatives, that you put in the named individual who would be immediately in place to make these decisions, but also be thoughtful about what happens if something happens to mom or dad, or could you list siblings or aunts or uncles or cousins or other close family members or friends. So you can think about this from a succession planning perspective as well. Okay. The HIPAA release is very important, as Ann correctly noted. As parents, once kids turn 18, you're sort of walled off with regard to privacy. I remember being stunned when my son was in school and I was paying for his tuition and realized that I would get the bill, but I didn't get the report card. Something was wrong with that picture because he had the right of privacy. And so that applies in HIPAA release. And so HIPAA and its Health Insurance Portability and Privacy Act, I think, and it's been enacted for some time now, but it's where private health information can only be disclosed with the specific authority of the individual, right? So that deals with, so you have to get a release from your son or daughter to sign a HIPAA release so you're able to speak to the physician. I understand, I live in the real world where often, medical providers have a history of relationship with the families, and often there's this understanding that goes on, and sometimes the physicians and the provider themselves, the PCP, might have a HIPAA release or may have a healthcare proxy that they would offer in the office. I know that's a practice in some providers. But the HIPAA release is a release of private health information. This is an immediate grant of authority, as is the durable power of attorney. It's typically an immediate grant of authority. Now, Massachusetts has a healthcare proxy statute. Other states have something called a durable power of attorney for healthcare. Other states have a healthcare surrogate legislation. All different words basically saying the same thing. You can make medical decisions for me when I am unable to make those decisions, or I am unable to communicate those decisions. This is a triggering event. It has to be a written determination, at least in the healthcare proxy, and it varies from state to state. So you have to check your jurisdiction. But the healthcare proxy is a springing authority. So if one goes for surgery and you give your consent for surgery for a specific procedure, but then there is an issue that arises during the operation or during the procedure that requires additional decision-making, but you're not able to give it, the healthcare proxy can be invoked. It's very common for folks who are older to need a healthcare proxy. When the healthcare proxy is invoked, the agent continues to have that authority around decision-making, and it's a broad authority. It's not only about treatment, it's about admissions and discharges, hiring and firing providers. So it's very broad. Once the capacity resumes, if capacity does resume, then the authority of the healthcare agent lapses. It's no longer is in effect. Several years ago, I looked at the durable power of attorney that we were using, and we still use a traditional one for banking and insurance because you're dealing with third parties who are familiar with certain provisions and forms. But for the vast majority of people that I work with who are turning 18, they have an intellectual developmental disability or other condition that will require lifetime services and supports. And they don't need a full-flung, fancy durable power of attorney. So what we use is an appointment of advocate that's more of a, looks similar to a supported decision-making agreement. But it has the agency. It's the person who is named as the attorney, in fact, or the advocate in the appointment of advocate. They're making the decisions and being able to talk to DDS, to talk to a provider, to talk to a healthcare provider, or a school system. So that's the penumbra, if you will, of options prior to guardianship, where someone is able to articulate that they want members of their family to be able to make decisions for them. And next is the trustee. A trustee, as many of you probably know. What's the protection we're being afforded here? Well, in a special needs trust and a supplemental needs trust, there's money aside, and there's multiple kinds. It's beyond the scope of tonight's 60-minute webinar to cover special needs trusts. But they are a protective device so that the individual beneficiary doesn't have direct access to those funds. So if it's a self-settled trust because somebody's got an inheritance, or they have some other type of income or assets coming in, maybe there was a parent died and they didn't properly title the life insurance policy and they put it in that person's name, we have to create a self-settled trust in those situations. In those situations, some situations you can do it outside of court if the person isn't under a guardianship or isn't under a legal disability, such as a minority. However, if they are a minority or if they're under guardianship, then you need to go back to court and create an estate plan within probate court. And this is where I'm going to turn things over to Ann Grenier, who handles a lot of our probate litigation, our DDS litigation. Ann's not only an attorney, she also balanced her academic graduate degree with an MSW. So she comes at this in a very holistic fashion. So Ann, I'm going to turn it over to you to get into some of the probate court proceedings for creating an estate plan.
Okay, thank you. So in other states, they do combine what we have in Massachusetts as guardianship and conservatorship. And either or can have the title and have the same functions. But here in Massachusetts, we have two separate titles. You can be a guardian or a conservator. And the guardian is somebody who's been appointed by the court to act upon for the best interest of the individual, for their health, their welfare. It's primarily for making medical and other decisions on behalf of the disabled person. You can manage some money, but it's limited usually just to having the social service, the social security benefits. And you can also do apply for like mass health and other social services that the person might qualify for. So basically in guardianship, what you do is you petition the court, and there's also, the court will have you give notice to all interested parties. So you might have to notify everybody in the family or anyone that the disabled person is living with, or also if they have services from the Department of Developmental Services, that they would also need to be get notice. And as part of the process, there is some medical information that the doctors need to complete. In Massachusetts, we have two things. We have, for someone who has an intellectual disability, they would need to fill out a clinical team report, which requires 3 professionals: a physician, a psychologist, and also a social worker to complete the form. The medical certificate is used for people who, have a disability, but not an intellectual disability. And that's a medical certificate, and that's just completed by the person's physician. And so after all that is after the notice is served, and after you submit all your medical information, a hearing is held. And then the court makes a decision about appointing the guardian. Is the guardian an appropriate person? Does that person have priority to serve, such as if they were nominated in a will, or are they a close family member as opposed to someone in an agency? And everyone gets to be heard on the day of the hearing. The judge also does consider what the disabled person's wishes are. So if you have 2 parents, the child may prefer one parent over the other, and the judge would then give the disabled person the right to participate in the choice. Guardianship can be what they call plenary, or it means that you can make all decisions, or it can also be limited. And the court, as I've been noticing more and more recently, I mean, of course, we promote asking the parents, which rights can your child retain? And so some of those rights would be the right to still vote, the right to drive, the right to smoke, the right to choose employment, to have friends, to be able to participate in your activities of daily living, maybe with assistance. So we have, and also to maybe administer some medications. There's a whole form, and you can add to it or not, or add with more supervision and oversight if you want. But the judge asks us specifically, are there any rights? And mostly the right to vote is highly encouraged, unless it's totally inappropriate. So more and more, even in guardianship, it doesn't mean that you lose all your rights. The court is very interested in making sure that there are limits to it, and they ask us about it. Another thing, there's sometimes in some states there isn't any expanded authority. You don't have to ask the court to be able to administer antipsychotropic medications or other procedures. But here in Massachusetts, in extraordinary situations such as antipsychotropic medications, any intrusive procedures or treatments, any admission to a nursing home, or if you want to do advanced directives, you have to petition the court and ask for expanded authority to do so. And then in those circumstances, the disabled person is given an attorney, and their duty is to make sure that this is what the disabled person wants, or to give them a voice. And so the court will, have a hearing on that to decide, the pros and cons. And in those circumstances, the court reviews those, the authority on an annual basis. So all of us get back together and we have the physicians complete medication affidavits suggesting whether that is still in the person's best interest or not. And also, if it is antipsychotropic medications, a treatment plan is established, and only certain drugs within certain ranges are allowed to be administered. And so the court really monitors those situations to make sure that are they being treated in the least restrictive possible way? Have they been trialing, medication, having them cut back on the medication? And the court really is quite involved in all those kind of decisions.
And I just wanted to jump in, please. As I shared, we might interject occasionally. There's a couple of questions I'd like to hold at the end, but one question came in. Is it possible that during the guardianship process, the guardian can state what rights their child can have? So if they want to allow their child to still vote, is that something that's done during that process?
Yes, that's done during that process, and it's submitted as part of a proposed order. So prior to the hearing, we submit a proposed order with these attaching the limitations and the rights they're going to retain.
Thank you.
And also with guardianship, although it's a state, it's specific by state, we can transfer guardianships. So a lot of times we have people from other states that move to Massachusetts, and there's a process between the two jurisdictions where one starts the process and gives us a provisional order, which we then file paperwork to accept the provisional order. So it goes back and forth, and we can transfer guardianships from state to state. And that's under the Uniform Adult Guardianship and Protective Proceedings Jurisdiction Act.
And one more question regarding guardianship. I had a conversation with someone on Facebook, and they're here tonight, which I'm really grateful that you're here. They had felt coerced to pursue guardianship, but now they're really looking at more of a supported decision-making process. How easy or difficult is it to move from guardianship to supported decision-making?
Well, that's a really good question. So, so what you would need to do is you'd need to have either it depends on if it's an intellectual disability or what or if there's some other reason for the incapacity. You need medical information. So you need a clinical team report, which is a court form, or this medical certificate. And the professionals basically have to say the person's competent now and that they can make decisions. And, I have had that happen. I've had that happen with a gentleman who had a stroke and who became regained capacity. I've also had that with someone who was who's disabled, intellectually disabled, but over time began getting the skills, and then a clinical team report was done, and they found that they were capable. And so once that is sent, filed in the court, we call that a termination of guardianship. And along with that paperwork, the court will accept it, and it can be dissolved.
What happens if a guardian passes and there's no other guardian listed?
Well, that's when you have to petition the court again for, so what we do is we resign the person because they've passed, and then we file a new petition petitioning, appointing somebody else. That's why a lot of times we advise to have maybe two guardians, and sometimes it might be a parent and a sibling. Sometimes, depending on, or if there's like a younger aunt or uncle, just so that there is, in case there is a gap. But even in that situation, we can go for temporary guardianship, and that can be done on an emergency basis. So if we really had to, we could get somebody appointed quickly.
So to that point, another couple of questions came in. Should both parents be guardians? And Fred, you and I talked about this.
Right.
And by the way, this is sort of a legal transition 101. We're going to do a deeper dive in the fall with Fred and Ann. But, you know, why should you not have both parents? I mean, obviously, if you want to pursue adult family care, which is a Medicaid funded program where someone is a caregiver for someone who has medical needs, you cannot be a guardian and be a caregiver. But what other instances would it not be a good idea to have both parents, or why would it be a good idea?
Well, in the absence of the AFC available, which you're right, adult family care in Massachusetts, that's not a national requirement. So, you know, that's a state option that the state chose independent of the federal Medicaid statute. So there may be other states that I don't know, but there may be other states that have an adult family care or a similar type of program where a parent is, you know, an assessment is made that the individual needs significant support and activities of daily living, hand over hand, around hygiene and clothing, dressing, and self-care. And they get paid a per diem amount, and there's usually a couple levels, and it's tax advantage, so there's no income tax paid. But the provider in Massachusetts, if it's a parent, cannot be the guardian. So in that instance, you know, one person serves as guardian and the other person serves as provider. And I'm laughing because there's a cleaning service out here vacuuming. So if you hear vacuuming going on, not at
Awesome.
it's the cleaning service. So it's going down the hall to Ian's office too. So
Just past me.
there, you know, if parents get along, there's really no good reason not to do a co-guardianship. And if they're not going to do AFC, then you know, it's always good to have co-guardians.
And and two, if one parent passes away,
Yeah.
it's fairly easy to just, you know, reappoint another person, another sibling to at that point. And if one parent is the guardian, one parent is not, what we have here is we do a delegation of authority form, and with that parent can say, I authorize, say it's the dad, I authorize my wife in my absence to make decisions just as I can in my, you know, in my absence. So they can take that to the doctor, or they can take, so that the spouse will be able to make decisions, even though they aren't the guardian. Okay. Oh, and just and to go back on another point, a lot of times I get asked this question. The guardian does not have any risk for the incapacitated person's acts or debts, and is under no obligation to provide a home or direct care to the incapacitated person. And then I wanted to make mention that again, the guardianship is court monitored. And so the guardian has to, you know, fill out an annual report. And if you're under Rogers guardianship and you're appointed what's called the Rogers monitor. And that's another report that needs to be filled out regarding the medication and the discussions you had with the providers and whether the medication is working and if you think there are any other issues. So the court monitors all of this very carefully. And if you don't submit your report, they'll send out letters and you would be at risk for being removed. There are some guardianships that have been, if they're old and there wasn't a reporting requirement, like, you know, decades and decades ago, they're grandfathered in, so they won't have those reporting requirements. Okay, so the second thing to talk about is conservatorship, which is different. The court gives someone the power to manage the disabled person's finances. And so this could be, you know, this is not the Social Security benefits or a small little bank account or something. This is like, much more, money than that. It's like, property and the like. And this is similar to guardianship. The court does retain oversight. You have to do meticulous record keeping, and there's an annual accounting that's due every year. Fred had mentioned about transferring sometimes some money into a special needs trust. And sometimes we do what's called a special conservatorship, or it's basically conservatorship for a limited purpose. And so we petition the court, and we ask the court to appoint someone who will transfer funds into a special needs trust to preserve the disabled person's benefits. So that might be an inheritance, that the person got an inheritance, or there was a court settlement. And we ask the court, can this person transfer this money over into a special needs trust? And once we have done that, we can show the court, here's the special needs trust, here's the bank account, this is where the money's been transferred, and we close it. And so that's one way to get out of the ongoing reporting for the conservatorship, and also to preserve the person's benefits. Part of the process too is that you can also ask the court to do an estate plan for a disabled person, so that they can maybe do some gifting and to preserve their estate in terms of taxes. But in these circumstances, the court will appoint what's called a guardian ad litem, or an investigator, so to speak. And they're going to look over to see what the estate plan or what the special needs trust, and they're going to make sure that we're doing what we say we're doing. And then the court reviews the guardian ad litem's report, and then we'll authorize that. So that is about. Do we have any other questions?
We have a couple of questions regarding divorce. So I'll ask it a couple different ways.
Sure.
If the person is not the guardian, can they set up a special needs trust and appoint a trustee that's not the guardian?
Yes, they can.
Okay. And if there's a divorce, and the custodial parent could be the guardian, and is the recommendation the same in previous conversations, that it would be a good idea to have an alternate in the case that person's not available?
So yes, all right. So in the case of a divorce, unless you get along and you're copacetic, I don't recommend that exes both be the guardian. Because you're nullifying the guardianship. If we have one person says one thing, the other person says no, then we have no decision. So I don't recommend that. And sometimes, we do have that where one ex-spouse petitions the court and the other one objects. And the court, the court will then, look at what the child, what the disabled person wants, looks at, who traditionally was the person who kind of managed the medical care, worked with the schools, and was really kind of in that caregiving function more than the others. Now, that being said, we do have divorced spouses who are able to make decisions, and that is appropriate in those circumstances. But unfortunately, as part of the divorce, I've seen people enter into judgments that require them to both be the guardian. And if that's the case, they're almost like hijacking the situation to make sure there's two guardians. But in the long run, it's not in the best interest if you really don't have that kind of cooperative relationship.
Yeah, I would just.
And that kind of relates to human nature. Sorry, Fred, go ahead.
So, Anne has a background in a lot of probate litigation, including many years in handling divorces, and she can tell you stories that I think if the relationship between the parents becomes so toxic that they can't make decisions on behalf of their child, there have been some limited situations where a court would say, we're going to appoint an independent guardian.
Right.
Because the court's not concerned about the parents who are not able to get along. They're concerned about the interests of the individual who's incapacitated. I want to go back to some basic concepts that to also make sure that we have covered, because we're running up against the witching hour here. The guardianship nomination, if when you pass away, can be made in your will. In the vast majority of states, if you have a will, and you have the ability to nominate a guardian, and you can nominate, a sibling, like another kid, and whatever, and if that person is unable to serve, then you can nominate someone else. The guardianship statutes, at least in Massachusetts, and most of the other states I also practice in, give priority to that person who is nominated by a parent or a guardian in their will. So if you're doing an estate plan, you want to make sure that the guardianship not only covers the statement in the will that says, if my child is a minor, but you also want to have a provision that says, if my child is age of majority and other least restrictive alternatives are unavailable, I nominate John Jones or I nominate Jane Doe to be guardian of my son or my daughter, name them, and go forward. So in a will where we have parents with minor children, but who also may be subject to guardianship because of the presence of an intellectual developmental disability, you'll see another paragraph in the will that will specifically talk about nomination upon attaining the age of majority. The other decision-making process that people go through is do I do least restrictive alternatives, or should I do guardianship? And one of the concepts that I would just throw out so you can, add to the marinade of your decision-making process, if you will, is that guardianship doesn't automatically have to happen at 18, okay? You can try these lesser restrictive alternatives. And if they don't work, you can always file a petition for guardianship. So it's not like you use it or lose it at age 18 or age 19. There's also flexibility. I'll give you an example of how this worked in one situation many years ago. And if I've used this example a couple of times, so if you've heard it, forgive me. But I think it exemplifies the fact that we're dealing with a system that can be flexible and respond to an individual's needs. I represented a family. A gentleman came in, he was turning 18, he lived in a residential school, he signed a power of attorney, healthcare proxy, HIPAA release, appointment of advocate, didn't see him again for 10, 12 years. They showed up in my office because he had developed a medical condition that required a transplant. And his father, it was one of those transplants where somebody can donate that organ. You can guess what it was. And the father was the perfect donor. Okay. And we're all set to go forward with the organ transplant. And the young man just froze. He just couldn't make the decision, and under those circumstances, he can't trump the parents because he was capable of making a decision. His intellect was just clouded with fear and trepidation. In that case, the alternative was, because it was a life-threatening condition and time-sensitive, we needed to file for a guardianship. And it was a limited guardianship for the purpose of getting this organ transplant for the pre-op, the op, and the post-op procedures, filed it in probate court, court appointed an attorney. The attorney did what's called a substituted judgment analysis. Too deep to go into this today, but they went through all the various factors, had a fact-finding hearing before a judge. The judge found sufficient evidence that if this person was competent at this time for purposes of this operation, knowing the risks and all the other risk factors and the probability of success, that he would consent. So he did consent. Following that, the guardianship was very limited, and I believe at some point the guardianship was then terminated and we reverted back to the supported decision, not the supported decision, but the alternative options that are available in Massachusetts through these other statutes. So that gives you a little sense, a little flavor of This is sometimes not a very straightforward path that we're going, you all know that. So the law is flexible and can deal with individual situations as they come up. Thanks, Tim.
Thank you, Fred, and I do want to be respectful for the hour that everybody's worked late and maybe has things to do. So I think we're going to put a close. If there's any final questions, there's a couple related to the state and DDS that I feel would be best answered in a different forum, because we can't really speak for DDS, even though Fred and Ann have a lot of experience with DDS. But those are very important questions, and I want to thank you. So we did put in Fred and Ann's contact information. We have a couple of resources. Let's just go back quickly, if we could go back to the contact information, and you will get a copy of the slide deck, right, Janine? Okay.
Yes.
Great. All right. So that's Fred and Ann. Thank you, Fred and Ann.
Thank you.
Thank you very much.
So here's a couple of resources that will be hyperlinked in your document that you can look them up. But we have, of course, Fletcher Tilton, our representation tonight, the Guardianship Center. The ARC has a lot of information, support decision making, and I've been heavily researching this, so feel free to reach out to me, of course. Mass Advocates for Children is a very great organization. And just to save the date, we do have an in-person event May 11th in Watertown on a Saturday. So save the date. We'll be talking about some amazing topics, including public benefits and housing. You're all welcome to that. It's a free event. We'll have good food and a half day, so it's doable on a Saturday. And one more thing, we have a summer series, and to complement today's discussion, our summer series is being hosted by the Transition Center, and our guests will be the Center for Guardianship and Excellence, which is a nonprofit, and they are an amazing organization. And we will be taking this topic and diving way deeper into 4 sessions in the month of June. So you will get information on that because you're members of this esteemed group. And finally, April 2nd, our next conversation is with Amy Weinstock. She's a parent advocate and she works for UMass Chan. The Autism Insurance Center will be talking about how to use your insurance beyond 26 and all other aspects of insurance that will help you. So I want to thank you all for being here. When we come together as a community, it creates a cohesive support system. Your questions really made this more dynamic and meaningful. Thank you, Janine, so very much for putting this all together in the high-tech way that you do. And again, thank you to the team at Fletcher Tilton. We really, really appreciate your presence. And I hope you all have a wonderful evening.